If you're a green card holder in America right now, you need to hear this. There's been a lot of confusion and fear circulating about new immigration enforcement policies in 2025, and some of what you've heard might not be giving you the full picture. Today, we're cutting through the noise to bring you the facts you actually need to know about your rights, what's really changing, and most importantly, how to protect your legal status. Whether you've had your green card for 2 years or 20 years, this information could be critical for you and your family. Stay with me because we're going to break down everything step by step. Welcome back to US Visa Updates, the channel where we bring you clear, accurate, and actionable information about immigration policy in the United States. I'm here to help you navigate the complex world of US immigration with facts, not fear. If you're new here, this channel is dedicated to keeping immigrant communities informed with reliable information they can actually use. We don't do clickbait, we don't spread rumors, and we always verify our sources before bringing you any update. Today's topic is especially important because there's been a lot of discussion, speculation, and honestly, some misinformation about what's happening with green card holders in 2025. We're going to look at what the actual policies are, what recent cases tell us about enforcement priorities, and most importantly, what you need to do to ensure your status remains secure. If this information is valuable to you, please hit that subscribe button and turn on notifications so you never miss an important update. And if you know other green card holders who could benefit from this information, share this video with them. Knowledge is power, especially when it comes to protecting your legal status. Understanding your green card status. Let's start with the fundamentals, because understanding what a green card actually means is essential to understanding your rights. When you receive lawful permanent residency in the United States, you're granted significant legal protections. You have the right to live and work permanently in the U.S. You can travel freely in and out of the country, and you're protected by U.S. laws and the Constitution. This isn't a temporary status, it's permanent residency, and that word permanent matters. However, and this is crucial to understand, permanent doesn't mean unconditional. Your green card comes with responsibilities and requirements that you must maintain. It also can be revoked under specific legally defined circumstances. This has always been true. What we're seeing in 2025 isn't the creation of new grounds for deportation, but rather changes in how aggressively certain existing grounds are being enforced and investigated. The law has always stated that green card holders can face removal proceedings for certain serious violations. These include committing certain crimes, abandoning your U.S. residency, engaging in immigration fraud, or in rare cases, activities related to national security concerns. What's different now is the intensity of enforcement and the expansion of scrutiny into areas that previously received less attention from immigration authorities. What's actually changing in 2025? So, what exactly is different about immigration enforcement in 2025? Based on verified reports and official statements, several federal agencies, including USCIS, Immigration and Customs Enforcement, and Customs and Border Protection, have received directives to increase scrutiny of permanent residents under certain circumstances. This represents a shift in enforcement priorities, but it's important to understand what this means in practical terms. The administration has stated that enforcement will focus on several key areas. First, there's heightened attention to criminal history. While serious crimes have always been grounds for deportation, authorities are now looking more closely at a broader range of offenses and reviewing cases that might have been previously overlooked. Second, compliance with residency requirements is being monitored more carefully. If you've spent extended periods outside the United States, you may face additional questioning when returning or during any interaction with immigration services. Third, and this is particularly relevant given recent cases, there's increased focus on what the administration terms national security concerns. This category is broadly defined and has raised significant concerns among legal advocates because it could potentially include political speech and activism. Fourth, There's attention being paid to public benefits usage, with some suggesting that extensive reliance on government assistance programs could be scrutinized. Though the legal basis for this as grounds for removal is contested and complex, it's essential to understand that even with these policy shifts, green card holders still have substantial legal protections. You cannot simply be deported without due process. Any attempt to revoke your green card must go through immigration court proceedings where you have the right to legal representation, the right to present evidence, and the right to appeal decisions. Only an immigration judge has the authority to order removal of a lawful permanent resident. The case that's getting attention. There's one case that's been generating significant discussion in immigrant communities, and it illustrates some of the concerns people have about the current enforcement climate. The case involves Khalil, a former Columbia University student and green card holder, who was arrested by immigration authorities following his involvement in organizing protests related to Palestinian rights and Gaza solidarity movements. According to reports, immigration officials accused Khalil of supporting Hamas, which is designated as a terrorist organization by the United States government. Initially, there was confusion about his immigration status, with some believing he was on a student visa. However, it was later confirmed that Khalil held a green card, which raised the stakes considerably because authorities then moved to revoke his permanent residency entirely. This case has sparked intense debate across multiple dimensions. From a legal perspective, immigration attorneys and civil rights organizations have expressed serious concerns about what they view as a troubling precedent. Their argument centers on the question of whether political speech and activism, even when controversial or critical of U.S. policy, should be grounds for deportation of a permanent resident. They point out that the First Amendment protects political expression and that conflating protest activity with material support for terrorism is a dangerous expansion of deportation grounds. On the other side, administration officials have defended the action as a matter of national security. They argue that there's a distinction between legitimate political expression and activities that cross the line into support for designated terrorist organizations. The question of where exactly that line falls and who gets to determine when it's been crossed remains highly contentious and will likely be tested in courts. For green card holders watching this case, the concern isn't necessarily about the specific facts of this particular situation, but about what it might signal regarding enforcement priorities. If activism or political expression can be interpreted as grounds for removal, many worry about a chilling effect on the exercise of constitutional rights by permanent residents. What immigration experts are saying, I've reviewed analysis from multiple immigration law experts, and there's a range of perspectives on what we're seeing. Some attorneys emphasize that the legal standards for removing a green card holder remain quite high. You can't be deported simply for unpopular opinions or legal political activity. Any removal case must be based on violations of specific provisions in immigration law, and the government bears the burden of proving those violations in immigration court. However, other experts caution that the current enforcement climate means that cases which might have previously been passed over are now being pursued more aggressively. Even if you ultimately prevail in immigration court, going through removal proceedings is costly, stressful, and time-consuming. The process itself can be devastating to families and careers, regardless of the outcome. There's also concern about what some call enforcement creep. Policies that begin focused on a narrow category of serious cases can gradually expand to encompass broader situations. What starts as enforcement against individuals with serious criminal records could potentially extend to those with minor infractions, expired documents, or other technical violations that previously would have been handled administratively rather than through removal proceedings. Several legal experts have emphasized that we may be entering a period where the gap between technical grounds for deportation that exist in law and the practical application of those grounds through enforcement is narrowing significantly. In other words, violations that were always theoretically deportable offenses but were rarely prosecuted are now being pursued more actively. Protecting your green card status. Given this enforcement environment, what should you be doing to protect your permanent resident status? Let me walk you through practical steps that every green card holder should consider right now. First and foremost, ensure you're in full compliance with all residency requirements. This means maintaining your primary residence in the United States. If you need to travel internationally for extended periods, understand the rules about maintaining your status. Generally, trips longer than 6 months can raise questions about whether you've abandoned your residency. If you need to be outside the U.S. for extended periods, consider applying for a re-entry permit before you leave. This demonstrates your intent to maintain U.S. residence and can protect your status during absences of up to 2 years. Second, keep your record clean. This should go without saying, but any criminal activity, even minor offenses, can potentially complicate your immigration status. Certain crimes, particularly those involving moral turpitude or controlled substances, can be grounds for deportation, even years after they occurred. If you do have any past criminal history, it may be worth consulting with an immigration attorney to understand whether it could pose any risk to your status and what, if anything, you can or should do about it. Third, file your taxes every year without exception. Failing to file taxes can be seen as evidence that you've abandoned your U.S. residency or that you're not fulfilling your obligations as a permanent resident. Make sure you're filing as a U.S. resident and reporting all worldwide income as required. Keep copies of your tax returns indefinitely, as they serve as important evidence of your continuous residency. Fourth, maintain accurate records and documentation. Keep evidence of your time in the United States, including lease agreements, utility bills, employment records, bank statements, and any other documents that demonstrate your life is centered in America. If you travel internationally, keep records of your trips, including dates, purposes, and durations. This documentation can be crucial if you're ever questioned about your residency. Fifth, keep your green card and other immigration documents current. If your green card is expiring, file for renewal well in advance. Don't let it lapse. While the expiration of your green card doesn't terminate your permanent resident status, having an expired card can cause complications when traveling, getting employment, or dealing with any government agencies. Sixth, and this is important, be mindful of your interactions with government benefits programs. While receiving benefits you're legally entitled to should not be grounds for deportation, there's increased scrutiny around public charge considerations. Understand what benefits you're eligible for and make sure any benefits you receive are ones you're legally permitted to access as a permanent resident. Understanding your rights. Even in this heightened enforcement environment, you have rights that cannot be taken away without due process. If you're ever approached by immigration authorities, you need to understand what those rights are. You have the right to remain silent. You don't have to answer questions about your immigration status, where you were born, or how you entered the country. You can simply provide your identification documents without engaging in further conversation. You have the right to refuse to let immigration officers enter your home without a judicial warrant. An administrative warrant signed by an immigration officer is not sufficient to require you to open your door. If officers don't have a judicial warrant signed by a judge, you can refuse entry. You have the right to speak with an attorney before answering questions. If you're detained or placed in removal proceedings, you have the right to hire an attorney at your own expense. While the government doesn't provide free attorneys in immigration cases the way they do in criminal cases, many nonprofit organizations offer free or low-cost representation to individuals in removal proceedings. If you're placed in removal proceedings, you have the right to a hearing before an immigration judge. You have the right to present evidence, call witnesses, and challenge the government's case against you. You have the right to appeal an adverse decision to the Board of Immigration Appeals and potentially to federal court. Understanding these rights is crucial, but so is being prepared. Right now, today, every green card holder should have the name and contact information for an immigration attorney readily accessible. Don't wait until you're in crisis to start looking for legal help. Research attorneys in your area who specialize in removal defense and immigration law. Many offer free initial consultations. Even if you don't hire an attorney now, knowing who you would call in an emergency is essential preparation. When to seek legal advice. There are certain situations where consulting with an immigration attorney isn't just advisable, it's essential. If you have any criminal history, even arrests that didn't result in convictions, talk to an attorney about whether this could impact your immigration status. Different crimes have different immigration consequences, and an attorney can assess your specific situation. If you've spent significant time outside the United States, or if your pattern of residence has been irregular, get legal advice about whether this could be seen as abandonment of your residency. An attorney can help you understand the risks and potentially take steps to strengthen your case that you've maintained your permanent residence. If you've been involved in any activities that could potentially be characterized as political, particularly if they involve controversial international issues, consider getting advice about whether this could expose you to any immigration risk. While political speech is constitutionally protected, the intersection of First Amendment rights and immigration law is complex, and having professional guidance can help you understand the landscape. If you've received any communications from USCIS, ICC, or any other immigration agency requesting information, additional documentation, or notifying you of an interview or hearing, don't respond on your own. Consult an attorney immediately. What you say and how you respond can have significant consequences, and professional guidance is critical. If you're planning to apply for citizenship, consider consulting with an attorney before you file. The naturalization process involves a comprehensive review of your entire time as a permanent resident. Any issues or concerns can be identified and potentially addressed before you apply, rather than discovering them during your citizenship interview. The path to citizenship. Speaking of citizenship, this is an important topic to address. For many green card holders who are feeling uncertain about the current enforcement environment, naturalization offers an additional layer of security. Once you become a U.S. citizen, you cannot be deported except in the extremely rare circumstance that your citizenship itself was obtained through fraud. If you've been a permanent resident for 5 years or 3 years, if you obtained your green card through marriage to a U.S. citizen, you're generally eligible to apply for naturalization. The process involves filing an application, completing biometrics, passing an English and civics test, and attending an oath ceremony. Citizenship isn't right for everyone, and it's a significant decision that comes with its own set of considerations. Some countries don't recognize dual citizenship, so you may have to give up your original nationality. However, for those who are eligible and for whom the benefits outweigh any concerns, citizenship provides the strongest possible immigration status. The current environment has led to an increase in naturalization applications as permanent residents seek the additional security that citizenship provides. If this is something you're considering, don't delay unnecessarily. While the processing times can be long, the sooner you apply, the sooner you can complete the process. Separating facts from fear. Throughout this video, I've tried to give you accurate information about what's actually happening with immigration enforcement in 2025. But I also want to address something equally important, which is separating legitimate concerns from unfounded fear. There's a lot of misinformation circulating on social media, in community groups, and even in some news coverage. I've seen claims that all green card holders are at risk of immediate deportation, that immigration raids are happening everywhere, that even minor traffic violations will lead to removal proceedings. Most of these claims are exaggerated or simply false. The reality is that the vast majority of green card holders who are in compliance with the law, who maintain their residency requirements, and who don't have serious criminal issues are not facing imminent deportation risk. Even in the current enforcement climate, the system has legal constraints, resource limitations, and procedural requirements that prevent mass removal of lawful permanent residents. That said, dismissing all concerns as overblown would be equally irresponsible. The enforcement environment has genuinely shifted. Scrutiny has genuinely increased. And there are legitimate reasons for permanent residents to be more attentive to maintaining compliance and understanding their rights. The goal here isn't to minimize real concerns, but to ensure those concerns are properly calibrated to actual risks. Panic doesn't help anyone, but neither does complacency. What helps is being informed, being prepared, and being proactive about protecting your status. Looking ahead, immigration policy is constantly evolving, and what we're seeing in 2025 represents a significant shift in enforcement priorities. Whether these policies will expand further, remain at current levels, or eventually be challenged successfully in courts remains to be seen. Immigration law is complex. Enforcement priorities change with administrations, and court decisions can reshape the landscape quickly. What won't change is the need for accurate information. This is why I created U.S. visa updates to cut through the confusion and provide the immigrant community with reliable factual information they can us.